My name is Kenneth McLaurin, and today is the first time we are doing our Assistant Attorney General presentation live on Zoom. Today's topic is tenant and landlord issues. I know this is something that is really important and touches a lot of people, especially in these times of COVID-19. I just want to let you know how we are going to Zoom today. Mike Danaher, the Assistant Attorney General, has a presentation that he will give for 45 minutes to an hour. If you have any questions, text them or write them in the chat. And after the first hour, he will spend another hour up until 1 o'clock answering questions that people have. Please keep your microphones on mute. And again, any questions or anything you have, please put them in the chat and we will respond to them. I'm Kenneth McLaurin. Thank you for tuning in, and we are going to turn it over to Mike.
Good to see all of you. In fact, I can see some of you, which is great to have as many people as we can. As Kenneth mentioned, I'm Mike Danaher. I'm an Assistant Attorney General in charge of the Binghamton Regional Office of the Attorney General. We hold these monthly consumer issue programs, mostly live. This is, as Kenneth mentioned, our first virtual consumer session at Cornell Cooperative Extension on the second Thursday of the month at 11 a.m. So I hope that once we're all back together, many of you 33 people who are in with us now, 34 now, will join us in our live sessions at Cornell Cooperative Extension. We talk about a whole host of different consumer-related topics. This does happen to be our number one topic. That's why we do it twice a year, and that's tenant and landlord rights and responsibilities. This area is in a state of flux. It is, first of all, the law changed regarding a whole host of landlord and tenant topics in June of last year with the adoption of the Housing Stability and Tenant Protection Act. It went into effect on June 14th of 2019, and it changed the entire landscape of landlord and tenant relationships. Then you throw on top of it the middle of the pandemic that we're in, and that there were some executive orders that were issued by the governor that also put into our stew and was stirred in so that we have a whole different batch of laws that we have to be concerned about when it comes into taking into account this whole area. So starting out, we'll just talk about, first of all, what goes on in this landlord-tenant relationship, and then we'll mix in the new laws. And for those of you that aren't aware of the new laws, we'll kind of contrast them with what the previous laws were so that we can see. And then we'll sprinkle in the executive order or requirements. So this new law that went into effect in 2019 was massive. It contains 15 different sections and encompasses 74 pages of changes to the real property law, the general obligations law, the real property actions and proceedings law, a whole host of things. It involves rent control, which we don't really have a problem or an issue with that in upstate New York. However, it does provide that certain communities throughout all of New York State could adopt rent controls depending on whether or not there's an emergency housing situation in the communities, and that's a community-based thing. So the county governments could determine that there's a housing emergency, or local municipalities could determine there's a housing emergency and adopt legislation that would then take into account rent controls. But those are principally involved in New York City, Long Island, surrounding counties to New York City, and we're not going to pay any attention to that right now. The new law dealt with leasing practices, notices that have to be given to tenants and landlords, eviction procedures that how you undertake those. And again, there were significant changes to what the law was before. And again, we throw in the Governor Cuomo's executive orders and most recent notices, which is most recent notices that I found out about an hour ago, related to the courts now opening up starting next week. So that throws in a whole nother set of time periods. So we can't possibly deal with all of these laws, all the executive orders, and handle them all in the course of our time period. So we're going to try and handle as many of them and the details associated with them in the allotted time that we have. So we'll get right into it. And the way that I have kind of broken it up is the different phases of the lease process. So let's first talk about the lease origination. Lease is really just a contract between two parties, a landlord and a tenant. And the landlord, as a part of the contract, does something, and the tenant does something. The landlords, what they do is they give up exclusive use and occupancy of a property. An apartment could be a room in a building, but let's just for our sake say that it's an apartment. So landlord gives up exclusive use and occupancy in consideration of which the tenant will be paying. And tenant agrees to pay for the exclusive use and occupancy of that property, and that payment is called rent. And so when the two parties come to an agreement, we have a contract. And that's really what a lease is. It's a contract between a tenant and a landlord. The terms of that contract govern the relationship. And the primary thing that we usually think about when we talk about rent, or we talk about a lease, is rent payments by a tenant and how much, and how long is the term for the lease. Now, usually there can be two sets of terms. One could be a specific term. Typically it's a year. It could be 6 months. It could be 3 months. It could be 2 years. It could be whatever period of time. But it's generally a set term. If the parties do not agree on a specific term, the law has in it a presumption. It's presumed to be a month-to-month tenancy, and there are ramifications for that. If the term expires and there's no additional agreement, it just goes on. The tenant just stays. The law converts the term to a month-to-month lease. So if it's a 1-year lease, but the tenant continues to stay, landlord gets the rent, it automatically converts to a month-to-month. And there are notice provisions and things that we'll talk about in a few minutes related to that. But everything that the parties agree upon should be a part of the lease. One thing I'm going to mention, I've mentioned every time we've done this program, is you do not have to have, by law, a written agreement. Doesn't have to be in writing. That said, I recommend both for the tenant and for the landlord, it's in their best interests to put everything in writing. Get it in writing. Then everybody understands who's responsible for what, who's going to do what, and it's written right on the paper. So if any question arises, you pull out the lease, you look at it, and that's what the parties agreed to. In fact, if the lease is for longer than a year, and those are usually mostly commercial leases, but they're, again, you could have a residential lease for 5 years. Anything greater than a year, because of another law that's out there, anything greater than a year must be in writing to be enforceable. So you really do need a written agreement if it's more than a year. So typical lease we're talking about is the standard year, and the provision is that that it's a year. Then if it goes past the year, then the it converts over to a month to month. So get everything in writing. I see in a lot of instances that a lot of the problems that occur is usually a miscommunication between the parties. Somebody doesn't understand, somebody thought this and the other side thought that. And if you have it in writing, there's no questions. For example, tenant thinks that the landlord should be shoveling the sidewalk. And the landlord says, no, tenant should be shoveling the sidewalk. Put it in the agreement. That way, if somebody says, oh, who's responsible for shoveling the sidewalk? You have it in the agreement. So put everything in. Are pets allowed? Tenants have to understand, because I've seen this situation happen. If the document says no pets, there are no pets. You can't have pets. So even if you bring in this cute little dog to live with you, there's no pets. So the landlord could say it's a violation of the terms of the lease because it has right in there. And then if the tenant says, well, I talked to the landlord and landlord said it was okay. If the landlord says it's okay, put it in writing. Even if it says no pets allowed except for Fido. So that way you can have. If you're 6 months into the lease, it's a no pet lease, but the landlord agrees that you can put a pet in, have a pet because the landlord, she likes the dog that you have. Put it in writing to amend that contract to say, yes, you can allow this particular dog in the property or cat. So that's just everything is in writing. It's so much better. A lot of questions can be answered because it's in writing, and you're all good. Now, as far as the lease origination and the parties agreeing to things, this new law that went into effect in 2019 had some provisions regarding what can be done and what can't be done. First of all, the landlord cannot refuse to rent to a tenant because the tenant was involved in a prior eviction proceeding. That would seem kind of odd to some landlords to say, why would I rent to this person when I checked the court records and I saw that the last landlord evicted this tenant? You cannot discriminate against someone, and discrimination is a bad term because that has a special legal significance. You cannot refuse to rent to a tenant because they were involved in a prior eviction proceeding. And it is, in the law, a rebuttable presumption that if the landlord requests information from a tenant screening organization, so you check a background check, so to speak, or reviewed court records prior to this deciding whether to lease the property to this tenant, and then the landlord refuses to rent to this tenant, it's a rebuttable presumption that there's a violation of that statute. And just for your information, landlords, just make sure that you're on the straight and narrow path. The Attorney General's office was given jurisdiction in those cases to sue the landlord for an injunction, and there can be civil penalties between $500 and $1,000 for doing something like that. So you cannot. Also, application fees. Landlords are not allowed to charge an application fee for a tenant coming in except for a background or a credit check, but the limit to the cost of that to the tenant is the lesser of what it actually costs the landlord, or $20. Again, whatever's less. So the most a landlord can charge for the credit check or background check or anything is $20, no more. Deposits. We see frequently that there's, you go into a lease and you rent you ask for up front in rent, the first month's rent, security deposit. Sometimes they ask for the last month's rent or 6 months of rent or whatever. The law now says that the deposits, so anything paid in advance, the first month's rent is due for that first month. So that's not a deposit. That's the payment of that first month's rent. But anything other than that, the deposit can be no more than 1 month's rent. We always talk about security deposits, and we always typically think that, oh, it's 1 month's rent, because that's what people usually do. Now the law says that it can only be up to 1 month's rent. So you are no longer able to collect as a deposit, security deposit, last month's rent, because that is a deposit for the future payment of rent. So you're taking it in advance and holding it. The statute says the deposit can be no greater than 1 month's rent. Also, as a part of the lease, late fees. I've seen some throughout the years. I've seen some pretty large late fees that were attached, like $25 a day or $50 a day. Now, the new statute that went into effect is that late fees are limited to 5% of the rent or $50, whichever is less. So again, the most that can be charged in a late fee is $50. So that's not a day. That's $50 for that month's rent. But it could be less if the amount of 5% is less than $50. For example, $600 monthly rental. 5% of $600 is $30. So the limit to that late fee would be $30. You may not charge more. The statute specifically provides that if there is a provision in the lease that tries to amend that, it's void. So it's limited to the 5% or $50, whichever is less. Also, late fees cannot be charged until after rent is not been paid for 5 days. So it can't kick in on day one if it isn't paid on the first day. Now, this is where we sprinkle in a little of the current pandemic governor's executive orders. The governor has issued an executive order that says late fees may not be charged for late rent between March 20th of 2020 and August 20 of 2020. So late fees are on hold until August 20. Now, if there were late fees that were due prior to March 20th, that's just part of would be added in. But no late fees may be charged during that period of time. Another provision with the law, not the executive order, but state law now, is that landlord must give a written receipt for cash payments. So if you receive a cash payment, give a written receipt. The other thing very important to landlords is keep rental records for 3 years. So even if somebody's moved out, keep your records around, don't destroy them until 3 years so that you have a record. Your receipt book or whatever other records you may have, they must be kept for a period of 3 years. Also, prior, again, we're talking about just as the lease is starting out, inspections. After the lease signing, after you sign a lease, and before occupancy, so there might be a week or a few days, whatever, the landlord must offer the tenant the opportunity to inspect the property with the landlord and go through. So it's the initial walkthrough, and you can jot down anything that may be wrong with the property that time. Burn marks on the kitchen counter, hole in the wall, whatever's may be damage to the property. You go through and you note it. And then there must be a written agreement showing these things that are the items that are wrong, and that at the end of the lease, of course, the tenant can't be charged for damage to those items that were discovered during that initial occupancy inspection. So those are the kind of things in the laws that go into effect at the start. Now let's talk about during the lease term. Well, most importantly, the parties are bound by what they agreed to. So if you agreed to be responsible the tenant agreed to mow the lawn, the tenant's responsible for mowing the lawn. Again, all in writing, it's great, less questions, less problems. Landlord's responsibilities in a lease. The landlord has the responsibility to provide a habitable residence. What's habitable? Habitable generally means that it needs to be livable, safe, and sanitary. So at the initial outset and going throughout the term of the lease, the landlord's obligation is to have a place that the tenant can live in there. Now, obviously, if the tenant does damage that affects its habitability, that's on the tenant. These are just things that are on the landlord. For example, let's assume that the hot water heater goes. Through no fault of anybody, these things happen. It's happened in my house. It's probably happened in many of your houses. If the hot water heater goes, that's not on the tenant. The tenant isn't required to pay to have it fixed, but the landlord is obligated to furnish it. So the landlord's got to get in there and get it fixed. When does she have to have it fixed? Within a reasonable time. What's that? Reasonable time is under the ordinary circumstances. How soon can you get this thing done? It may take a day or so to get the plumber out to put in a new hot water heater. That's fine. But it's the landlord's responsibility. The landlord has to get it done within that reasonable period of time. I think a good rule of thumb is if that was the landlord's house and he or she was living in that house, how long would they take to get their hot water heater fixed? That's the time period that's put onto the landlord for the tenant to have theirs fixed. So it's the landlord has to provide a residence that's livable. So we're talking about shelter, heat, water, hot water, those sorts of things. Doesn't mean that the landlord has to pay for the heat or pay for the water bill. That's the agreement between the parties, who's supposed to pay for it. The obligation on the landlord is to have the facilities working so that it can be provided. If the agreement between the parties is a certain amount of rent, and included in the rent, the tenant has to pay for the water bill that comes to the unit, then the water bill comes. It could be that the landlord has the tenant put the water bill in the tenant's name. So the bill comes to the tenant and the tenant has to pay it. That's fine. And if it doesn't get paid and the water gets shut off by the municipality because it was the tenant's obligation and the tenant didn't pay it, and then the municipal water service comes out and shuts it off, that's not on the landlord. However, if the obligation for payment is included in the rent and the landlord pays it, the landlord must make sure it gets paid. And we'll talk about that in a couple of minutes because there's some serious consequences if the landlord shuts the water off when it's not supposed to be shut off. So it's the landlord's responsibility. What can happen in the case of the landlord not furnishing what a habitable residence? Well, one option for the tenant is to withhold paying the rent. I don't often recommend that simply because then the tenant is buying themselves a lawsuit because they'll then be evicted because they didn't pay the rent and you get into that fight. But it's an option that's out there. If the landlord is not furnishing a habitable residence, the court could say, tenant, you don't owe this money because the landlord's not furnishing what he or she had agreed to furnish, or the court could reduce the amount of rent that's done. It's called an abatement, a rent abatement, if that's not being done. So that's one option. Another option, and I know this isn't a good option for tenants usually is the tenants could sue to have a rent reduction done. Another option that the tenant has is to call code enforcement. If the premises is not habitable, I generally think, again, it's not a hard and fast rule, but a good guideline is code. If there's some serious code violations and things, tenants could call code and code could come in, and then what'll end up happening is code would notify the landlord that these things have to be remedied or they'll get fined or the building gets shut down or something like that. So the tenant could do that, and the code could come in and they could make the landlord do the things that need to be done to make it habitable. Here's where we have to sprinkle in again the new law that went into effect in 2019. The Home Security and Tenant Protection Act, as it's called, specifically provides that the landlord cannot retaliate against a tenant for making a good faith complaint to a municipal authority, or frankly, for making a complaint to the landlord either, saying, hey, I don't have water here. What's going on? The landlord cannot retaliate. And what's retaliation mean? Retaliation means is refusing or trying to evict them, terminating their lease, not renewing their lease, or if they say, well, I'll renew your lease, but I'm going to increase your lease by 50%. An unreasonable increase in future rent would be considered retaliation if done in response to a complaint that was made by a tenant to a government authority regarding the condition of things. And the law also threw in a thing called a rebuttable presumption. So it's presumed, the law presumes that if a landlord does any of these things, refuses to release the property at the end of the lease, or unreasonably increases the rent for the new term, or substantially changes any of the lease terms, it is presumed to be retaliation if this is done within a year of the tenant making the complaint. That's what it is. That would then put upon the landlord the obligation to show to the court it wasn't retaliation, it was for some other reason why they're not going to release, or that the rent got increased by so much or anything like that. But there is a presumption going in, and it has to be rebutted by the landlord or the landlord loses. So that's an interesting piece, and people need to be aware of it. One thing that comes up frequently is what responsibility does the landlord have for other people in the unit, in the building? Let's say it's a 4-family. And as a general rule, the landlord doesn't have the obligation to protect one tenant against another tenant. So the typical situation is when one of the tenants in the building is really noisy, playing music till all hours of the night. It's not really on the landlord to take care of that issue. How would you take care of it? How would you take care of it if you thought about the fact that, let's say you lived in a house and the person next door is having raging parties at 3 o'clock in the morning, you have to get up to go to work the next day. You call law enforcement, and that's the same thing that you would do here. It's not the landlord's obligation, it's the people who live in the building. They got to figure it out, work it out, call law enforcement. All the landlord did was give you a habitable residence and exclusive use of your residence. But he or she did that for the other people in the building as well. So what do? You call law enforcement. I would still notify the landlord that this is going on, because my experience has been that a good landlord wants to have good tenants and wants to take care of his or her tenants. And that if one person is causing a problem for 3 other tenants in the building, landlord usually wants to do something about it because he doesn't want to lose the 3 good tenants to because of one bad one. So notify them, notify a landlord anyway, keep the communication going. Some might try to argue that that's a breach of the warranty of habitability because you don't have safe safe living environment because you can't sleep in the middle of the night. And I don't know that there's any cases that have come out to say that that in fact is a habitability issue. So I just leave that out there that really you should contact law enforcement, notify them, and see if that can get resolved. Also, during the term of lease, what's the tenant's responsibilities? We have the landlord responsibilities. Well, tenants have responsibilities too. One is pay the rent, pay it on time. We're going to talk about what impact the executive orders have had on that in a few minutes. But rent's due, rent should be paid on time. Tenant has the has the responsibility to keep the property up. What the tenant must do is must return the property in the same condition as it was received, reasonable wear and tear accepted, meaning what reasonably wears down over a length of a lease. Over a year, it's usually not too much. But if somebody's resided in the property for 10 years, carpets may wear out, things may get dull, eventually things have to be repainted, those sorts of things. In the ordinary course of living in an apartment, nothing extraordinary is taking place. Just, carpet has worn out because you've just been there for so long. That is not the tenant's responsibility because the tenant returns the property in the same condition it was received, except for reasonable wear and tear. Things wear out. That's what happens. That's the cost of doing business for the landlords. If, however, the tenant causes damage, breaks things, puts holes in walls that I can't see in any way would be reasonable wear and tear, they're responsible for the cost of that repair. Kind of correlated to that is the security deposit. As I already mentioned, the security deposit is limited to 1 month's rent. That's all that can be collected as a security deposit. A couple of things related to security deposits. One is it always remains the property of the tenant. If you keep that in mind, you can answer most questions as it relates to how you handle security deposit. One is landlords, because it's the tenant's money, landlords cannot commingle, put together the rent security deposit with the other money of the landlord, because then it kind of changes its existence from being owned by the tenant to being owned by the landlord if the landlord is putting the money in with all its other money. And there's a reason for that. And it's actually a psychological reason. The psychological reason being is you have a lot less incentive to give your own money back to a tenant than you do to give the tenant's money back to him or her. So the law wants it kept separate so that at the end of the lease, assuming there's no damage, no money's owed, it can be given back to the tenant. It's the tenant getting back his or her own money, not the landlord having to dip into his own pocket and then having to pay out the money, because then there's less incentive psychologically to do that. So it must be kept separate. In all cases, it must be kept separate. Theoretically, if the tenant hands the landlord $500 cash, the deposit goes in the left pocket because the landlord's own cash is in her right pocket. It should be kept separate. If it's in an interest-bearing account, in some instances it has to be, but if it's in an interest-bearing bank account, the interest belongs to the tenant. It's the tenant's money, the tenant gets the interest. There's not a lot of interest, especially nowadays. The law does provide that if the building is more than 5 units, so 6 or more units, it must be put in an interest-bearing New York bank account. financial account. Must be kept separate, a separate security deposit account. You can open up a separate account and an interest-bearing account and put the security deposits in that account. And at the end of the lease term, again, assuming no problems, no damage, anything, the money plus interest can be returned to the tenant. However, most of this is more of a technical legal argument, and the reason being is the law does allow the landlord to keep 1% as an administrative fee for administering the trust account. And since the interest-bearing bank accounts are very easily paying below 1%, really the landlord could keep that as an administrative fee if he or she chooses to. In a lot of instances, the landlord doesn't really want the hassle of that and ends up paying it back to the tenant. But if it's greater than 1%, the difference still has to be paid back to the tenant, and it's the tenant's money. And at the end of the lease, it must be returned. Let's talk about the executive order. We're in that pandemic situation, and the landlord, the governor just recently signed an executive order. Now, I'll tell you, the executive orders start with a large number, and then there's a dot, and then there's some other numbers like a decimal point. The ones dealing with this pandemic starts at Executive Order 202. He's in Executive Order 202. So it's 202 point, and we're already up to 202 point, I think 30. So since the pandemic started, there's been 30 different executive orders issued for a whole host of different things. But in one of those 202 point whatever executive orders just recently issued, and I think it was 202.28, provides that the tenant who has paid a security deposit can request, and the landlord shall allow the tenant to request to use their security deposit to cover the rent. If the tenant requests, it said the executive order said, if the tenant requests, the landlord shall grant them the ability to take that security deposit and apply it to the outstanding rent to help out the tenant who doesn't have the funds to pay that rent. And here's how it goes. There should be a written agreement saying that the parties have agreed that the rent that's being held in security deposit will be used as the rent. This executive order specifically provides that the landlord cannot force the tenant to agree to that. It's totally up to the tenant to decide whether or not he or she would want to use their security deposit. Then the security deposit has to be paid back. And the executive order provides that starting the 90th day after the parties have agreed to use the security deposit as the last month's rent, or as the rent that's owed, that rent, it shall be repaid 1/12, in other words, be paid monthly, starting 90 days after the agreement took place. So as a practical matter, what happens is the parties agree, they have a written agreement, landlord is able to take that security deposit and apply it toward the rent, and then 90 days later, in addition to, hopefully we're through all this thing and rents, people are back working, and I don't know if that's going to happen or not. Every month, the tenant would pay their rent plus 1/12 toward the security deposit. So ideally, a year and 90 days from that agreement, you'll be back at square one. The security deposit will be back in place, rents will be current, and people will be moving forward. So that's the executive order as it relates to security deposits. So we go through the whole term of the lease, and we're getting near the end, and what has to end up happening? First of all, let's talk about notices. Here's notices. The Housing Stability Act that was enacted in 2019 provided, now this is the way it used to be. The way it used to be was if it was a year lease, at the end of the lease, everybody walks away. No problem. It's the end of the term. Here are the laws have changed. Here's the provision. The landlord must give written notice to the tenant a certain period of time before the end of the lease in two instances. One is if rent is going to be increased by more than 5%. That's one. Two, if the landlord has decided that they are not going to renew the lease. So if the landlord decides they're not going to release, or the rent's going to be jacked up more than 5%, the landlord must give advance notice to the tenant. And here's the time periods. If it is a lease that's month to month or for less than a year, if it's a lease that's less than a year, typically month to month, but it could be 6 month, three-month lease. 30 days prior to the expiration of the period when the landlord's not going to renew the lease, they must give the tenant notice that they're either going to not renew or the rent's going to go up by more than 5%. If you don't give that notice, then the notice does not take effect until after the 30 days has expired. You got to give at least 30 days. So if I'll use an example, if there's a week to go, it's a 6-month lease and a week to go before the end of the 6 months, the landlord decides to increase the rent by more than 5%. That designation, because it was only a week, it wasn't the 30-day notice, the increase would not occur until the following month. So you got to give at least 30 days notice to renew or be out. Or if you didn't want to renew and it was a week before the end of the lease, you could not give them notice to be out until the end of the following month if it was a 30-day. Okay, that's one time period. The other time period, if it's a lease for a year or longer, up to 2 years. If there was a lease for a year, or the tenant has resided there for a year or more, which is maybe there's a month-to-month tenant that's been there for 14 months, that notice we talked about is 60 days. So you have to give the notice of an increase in rent by more than 5%, or to a tenant who's been there longer than a year but less than 2 years. You have to give them 60 days notice. The third time period is if the tenant has been there for at least 2 years, it's a 90-day notice. So a 90-day notice to terminate the lease, or a 90-day notice where the rent is going to be increased by more than 5%. You must give those notice periods. So it's pretty significant. It never used to be like that. On the other hand, tenants. The law gives the tenant a little bit of an advantage here in that the tenant only has to give 30 days notice, even if they've lived there for 5 years. If they're on a month-to-month tenancy, they only have to give 30 days notice. Plus, if it is a term lease, so if it's for a year, the tenant just has to vacate at the end of the year. There is no notice required under the statute for that. And also, any attempt to remove that notice provision for the tenant, like saying, hey, tenant, you've got to give me 6 months notice put in the lease, is considered void. The other thing that the tenant, the tenant must, or the landlord must do is, let's take the situation that it's a year lease, tenant wants to get out after 6 months. Well, the tenant agreed to be there for a year. So based on contract law, the tenant has to pay for that year period of time, even if they want to leave early. However, I think this was always the law, but it wasn't written down. It was always part of what we refer to as the common law. Standard contract principles are that the person who has had their contract breached, the other side breached the contract, must mitigate their damages. And it's now written in the law, which says if the tenant leaves early and is still obligated, the landlord must mitigate his or her damages, meaning the obligation is on the landlord to try to find a new tenant who will pay the lesser of the fair market value of the rental apartment or what the tenant was paying when they left early or left without proper notice. The landlord has to try and find somebody. So the landlord can't just sit back and say, hey, I'm going to get 6 months more of rent. I don't have to rent this place out to anybody because my tenant still owes the money. The landlord must mitigate his or her damages by going out and finding a new tenant in a reasonable and customary way. You advertise it, do whatever you would normally do to find a new tenant. And when a new tenant comes in, then the damage obligation of the tenant, the previous tenant, is absolved. So they don't have to be responsible for the rent any further. So that's a provision that's now in the statute. Additionally, if the lease is coming to an end, the landlord must give written notice to the tenant between 1 and 2 weeks. It's a window, 1 and 2 weeks before the end of the lease, the opportunity for an inspection. To look, this is before the tenant moves out, to do an inspection of the premises, to go through and figure out what it is that might be wrong with the premises. And if the tenant says, I do want to have that inspection, I want to go through that inspection with you, then the landlord must provide an itemized statement of all the things they found wrong with it. Now, I understand while moving out, if the tenant causes damage, that's a whole different story. But we're just talking about what damage exists shortly before the end of the lease. The landlord must provide written notice that the tenant would have the right to go through the premises with the landlord on 48 hours notice to go through the premises. It can't be just knock on the door, showing up saying, I'm here for an inspection. You got to give them at least 48 hours notice. 1 to 2 weeks prior to expiration, that you can go through, have an inspection, and document everything that was wrong. Here's another thing. This is really important for landlords. Really, really important. Which is you don't have a really long time after the tenant leaves to figure out how much the damages are. What the law now provides is that within 14 days after vacating the premises, the landlord must provide the itemized statement of the damage. So you've got to get your estimates, you got to really hustle, get all this stuff done, and provide it to the tenant. Or if you don't do that, you may be forfeiting your right to retain any of the security deposit. So what you have to do is go through it. If there's somebody put a hole in the wall and you look and it's $250 to fix and you have a $600 deposit, what you have to do is you have to get the itemized statement showing it's going to cost you $250 to fix that hole, and then only retain the $250 and return the rest to the tenant within 14 days. So again, a fast time period. I realize that, but that's what the statute says. As we're fast moving along our time period, let's talk about the end of the lease, or making the lease end at a certain time. And that's with how does it end? Well, we talked about before. If the tenant wants to get out, at the end of the lease, they move at the end of the year. They move and it's over with. But let's assume for the moment that that's not the case. And what happens is the tenant decides to stay. That's called a holdover. A holdover tenant is a tenant who resides at the premises after the expiration of the lease, whether it's the expiration of a 1-year lease or it's more than 30 days after the 30-day notice was given in a month-to-month situation, or 60 days or 90 days notice we talked about before. The tenant stays. That's a holdover. If the tenant stays and the landlord wants the tenant out and the tenant is holding over, the landlord in no case, whether it's holdover or failure to pay rent, in no case can the tenant throw or the landlord throw the tenant out. In other words, without a court order. So if the landlord tries to change the locks, turn off utilities, harass the tenant to get them to leave, calling them at all hours of the night, some type of way that you're interfering with the quiet enjoyment of the premises, that's considered to be self-help, and that is considered to be unlawful, and it's really serious. If you do that, understand this, landlords, it's a crime. You can be arrested for doing that. So you cannot engage in self-help to evict a tenant who is holding over or who is behind in rent. And that's especially true now. Our office has received a lot of complaints from tenants who are being harassed by landlords, trying to be forced to leave during the pandemic. It is considered to be self-help, and it is a crime. Not only is it a crime, but it's also a civil violation that could subject the landlord to a civil penalty of up to $10,000. So arrest, up to $10,000 as well. Don't do it. You cannot do that. So if the tenant doesn't leave at the end of the term or defaults in the rent, hasn't paid the rent, won't leave, the landlord must get a court order. It's called a summary proceeding. Has to bring a proceeding in court, and we'll talk about it in a minute. Landlord cannot engage in self-help, can't cut utilities, change locks, harass the tenant, or engage, what the statute says is engage in a course of conduct that interferes with or intends to interfere with or disturb the peaceful occupancy of the tenant. Again, Class A misdemeanor if it's a violation, as well as a civil penalty of anywhere between $1,000 and $10,000. So let's talk about a failure to pay. The eviction procedure, I'll talk about holdover tenants in a minute. The procedures are generally the same, except that there's some notices there. There's certain steps that have to be made, and these certain steps are time consuming. It takes a long time, and you have to meet all of these time periods. If you don't meet these time periods, your case will be thrown out and you have to start over. So you want to make sure you do everything right. All of these provisions regarding notices have been affected by the new law that went into effect in 2009. And that is the first thing that you need to do. Remember we said you can't have a late fee start until after 5 days. Well, the first thing that in a failure to pay rent situation where a landlord wants to have a tenant evict, the first thing they have to do is they have to send a 5-day reminder notice. So rent's not paid on the first of the month. Landlord gives a notice to the tenant. Hey, a reminder, rent was due the first. This is it hasn't been paid, 5 days hasn't been paid, you need to pay. The second thing a tenant must do, or a landlord must do to a tenant is, and this is where the rules changed a lot. Before you can start a non-payment eviction proceeding, you must, and separate from the reminder, you must provide the tenant with a 14-day written demand that's served on the tenant that in essence says you have to pay or vacate. 14 days. The old law was 3 days. Now it's 14 days. And I call that the first 14-day notice. That 14-day notice is a precondition to starting the eviction action. So you got to give the 14 days. So we're talking about 5-day notice, 5-day reminder, 14-day notice, and there's no case law yet that I'm aware of that determined if you can give that 14-day notice at the same day that you give the 5-day reminder. I don't know how that's going to be played out. Some people are taking the position you need the 5-day reminder first, then you can do the 14-day notice. There's been no decisions on it yet, and the statute is unclear. But you've got to give the 14-day demand, pay or vacate. If the tenant vacates, then there's no eviction proceeding because the tenant's gone, and then the landlord would have to sue in small claims court or somewhere to get whatever rent would be due. But before you can do the eviction to have the tenant removed, you've got to give that 14-day demand. Then after the 14 days ends, you got to start your eviction proceeding, which is the serving the eviction papers, which is a notice of petition and petition to get the property back. And that must be served, again, talk about these time periods we're talking about. That has to be served between 10 and 17 days prior to the court hearing. So you've got to check with the court, find out what court date you have, count back 10 days, count back 17 days, and in that 7-day window, you have to serve the papers on the tenant. If you serve it 8 days before the court hearing, case will be dismissed. If you serve it 18 days before the court hearing, case will be dismissed. You got to serve it in that window. You have to dot all your I's and cross all your T's, or you got to start over. And you don't want to do that with these time periods we're talking about. So let's talk about the old time for the 10 to 17 days. That used to be under the old law 5 to 12 days. So it's added some extra time there. Then when you go to court at that time period, typically what would happen in the olden days is that if the tenant can't pay the rent, the judge will issue a thing called a warrant, which is a court order saying the property goes back to the landlord. Well, the statute provides again that if either party, when they're in court, requires an adjournment to prepare for a hearing on the issue of whether there's rent due or anything, the court must grant the adjournment of no less than 14 days. So now you're throwing on another 14-day period at least. It's got to be at least 14 days. So that's another period that could be thrown in there. If neither party asks for an adjournment, then the case goes ahead. Let's assume for the moment that the court decides that, yes, the rent is due, it wasn't paid, property goes back to the landlord. So the judge signs the warrant. That warrant has to go to law enforcement. In most instances in our areas in upstate New York and the southern tier, we don't have town constables anymore. They just went out with budget cuts. When I first started practicing law, cities used to have city marshals, towns used to have town constables, and they could be the ones to serve the warrant. Most of those we don't have anymore. So it's usually the civil division of the county sheriff. You got to call the county sheriff. And they have to serve the warrant on the tenant to say get out. Here's the problem. In addition to serving the warrant, the law enforcement also serves what I refer to as the second 14-day notice, which is there must be at least 14 days from the time of the service of the warrant till law enforcement will come back to make sure that the tenant is gone. So you see all these time periods. Under the old rules, with the 3-day notice, 5 to 12-day notice, and then the second, the warrant notice that the sheriff would serve was only 3 days before, you could get somebody out in 11 days. Usually didn't happen that way. It usually was longer than that, but you could do it within 2 to 3 weeks. You could have them out. Now, if you exclude the 14-day adjournment if either party could request. The earliest you can get somebody out is 43 days. And if somebody asks for a 14-day extension and they get 14 days, that's 57 days. So you're already into almost 2 months before this whole process hashes out. That's why I encourage landlords, dot all your I's and cross all your T's, because you don't want to get, you don't want to be in court in 20 some days and have the judge dismiss and you have to start over again because you missed the time period. Make sure you do that. It gets confusing. Make sure you do it right. Now, here's the other thing, which can be frustrating for some, is rent can be paid up until the day that the eviction is executed. So you go to court, tenant walks in and has the money for the rent, case done. Landlord has to accept it, and everybody moves on. Here's the other thing. For a summary proceeding, only rent has to be paid, not late fees. Even if you term the late fees in your contract to say late fees are considered additional rent, nope, late fees are not included. It's just the base rent. So up until the time the eviction, the sheriff's there to actually throw the tenant out, if rent is paid, that's it. Again, you can, in an eviction proceeding, if rent is owed and the tenant has been personally served with the eviction papers, the landlord can get a money judgment for the amount of the rent. But again, it's only the base rent, not additional fees, expenses, attorney's fees, nothing are added into that. You have to sue separately for that. Moving on quickly, because we've already run out of time, but I'll touch on those holdover tenants. Those who are staying past their term, you can avoid the first 5-day notice of rent reminder. Second, if everything else is the same, you still have to have the 14 days, the 10 to 17 days, and then the 14 days to ultimately get the tenant out. So the procedures are still the same. Just throwing in these executive orders, and I'll end up with this as far as eviction goes. We just received notice, like I said, an hour ago, that the courts in our area are opening on Monday. Previous to this, the courts were shut down to only essential cases, and the essential cases are very limited, and they did not include evictions. So things are opening up now, which, when they open up, would allow for holdover proceedings to be filed, separate from the non-payment proceedings. The holdover proceedings can be filed. There is some question right now, because of the way the executive orders are worded, of whether or not the non-payment proceedings can be started. Okay? Just the proceeding can be started. The executive order that originally went into place back in March said that evictions cannot be executed, meaning the sheriffs can't go out and evict people until, and what is now been extended till June 20th. The holdover proceedings would be able to be brought, but execution of any warrants cannot be executed until June 20th. Okay, that's the holdover. Recently, the governor has issued a new executive order that says no eviction proceedings may start. In other words, can't be filed. Can't take any steps to do an eviction for non-payment for someone who is qualified for unemployment insurance, unemployment benefit, or who have financial circumstances that they're having financial issues due to COVID-19 that makes it so they can't pay the rent. You can't start an eviction proceeding and executions cannot be executed, that cannot be enforced until August. Well, evictions can't be executed until August 20th. However, in the language of that executive order, it says you can't start an eviction proceeding for non-payment of rent due to COVID-19 starting June 20th. So the big question then is what about now? If courts open up and you have a non-payment proceeding, the executive order says you can't start a case, but it only set it from June 20th to August 20th. It didn't say about it now. I think there may be some clarification between in the not too distant future about that sort of thing, but any way you look at it, an eviction enforcement for someone who is non-payment because of lost his job because of COVID-19 is the classic example. The eviction can't be executed by the sheriff, law enforcement, until August 20th. So what happens in the meantime? Tenants are still staying there, and that's what we have to live with as far as what the executive order puts into play. So there's a whole host of things, and it's evolving daily, if not hourly, when it deals with eviction matters. The most important thing right now is tenants to understand you cannot be harassed to have you leave. Landlords, you cannot harass them, can't shut off utilities and that sort of thing. What we've been telling tenants is if something like that happens, call police, call law enforcement, because it's a crime. You can also notify our office, but if you call us, we'd say in the immediate instance, somebody's there to try to change the locks right now, call the police. And also the landlord could be subject to an enforcement action by our office if they're engaged in this repeated and persistent violation of the statute. So really mind what the law is, follow those provisions. Hopefully we'll get some clarity over the next few weeks, but we can hopefully all understand what's taking place now, and hopefully everybody can work it out and get the matter resolved. So Kenneth, I'm going to throw it back to you because I'm way past my time, and I've seen there's millions of questions that have been coming in during this period of time. So I'm going to leave it to you to fire some at me so that we can try and handle some.
I'm not saying anything.
In the future, just pick some.
Can I close it up?
Fine.
Sure. I need to have lunch.
Kenneth, do we have any questions? I'm sure
Talking, maybe they don't even know it.
Yeah, why don't you
I'm seeing one right now because Kenneth hasn't popped up, so we'll wait for him to pop in. I saw him.
Here we are. Can you hear me, Jim?
Yeah. Okay. Throw them at me.
All right. So the first question was, what is the law? What does the law state in general when the tenant wants to leave the property early, prior to the leasing agreement period ending?
Can't leave early. I mean, you have an agreement. That's what it says. If the tenant leaves, as we talked about during the talk, the tenant is still responsible to pay the rent.
All right. Next question is pets versus emotional support animal.
I hear you.
Okay, can you hear me now?
Yes.
I'm on the telephone. You muted me, so I don't. Again. I'm okay. You keep muting me when you mute everybody else. Let's talk about the first one before. If the tenant leaves early, they're still obligated under the lease, but the landlord is obligated to mitigate their damages. So they have to try and find a new tenant. And once they find a new tenant, then the lease obligation will end. What was the next one you have, Kenneth?
Pets versus emotional support animal.
An emotional support animal and a service animal is not a pet. So the rules of pets don't apply to them, and that's governed by the laws for service animals, which means a landlord has to make a reasonable accommodation to a tenant so that they would allow to bring in their service animals, comfort animals.
I think our next question is around declining to rent to a tenant based on a prior eviction proceeding. The question is, regardless of outcome, can
Yes.
we?
You cannot.
All right. And somebody says, what about the inability to pay rent? Can we decline to rent to somebody based on their inability to pay rent?
Yes. You can do a credit check, and if it shows that they're a poor credit risk or something like that, that's allowable. Here's the big gray area is your determination that they're not able to pay rent because they got evicted from their last place. You cannot use that. You have to go on what the landlord would normally do when they look at a credit report or bank statement or employment records or things like that.
All right. Next question is, how should a tenant proceed if there are clauses written in the lease that are in direct violation of tenants' rights as per the updated New York State laws put out in 2019?
They're considered void. So you can't, they have no effect. You can't, some could argue though, that if you know that they're not supposed to be in the lease and you put them in the lease anyway, that could be a deceptive practice. If you don't have any knowledge, and let's say you had an old lease that was before the statute went into effect. Let's say you entered into a 2-year lease in January of 2019. Those provisions that were in there are void. They're of no legal significance whatsoever. It would be helpful if you sent a notice to the tenant saying this particular provision is amended by the statute and you'll be given notice according to the statute instead of what our agreement was previous.
All right. The next question is a little deep. Can the lease condition continued occupancy on the tenant's immediate payment for tenant damage beyond the amount of security deposit equal eviction?
I don't understand the question.
I think the question is that if the tenant is in the apartment and they create damage in the apartment that is past the security deposit, is that equal to eviction?
You can evict people. We didn't really touch on this that much, but you can evict people who are quote unquote objectionable tenants that are destroying the property. And then you can proceed ahead with an eviction if you're noticing someone is causing so much damage that you won't even get your security deposit back. So you can do your eviction proceeding as an objectionable tenant.
This is a question. How do you define reasonable in some of these situations?
You know me, Kenneth. I've talked about this before. Reasonable is a term that lawyers get paid a lot of money to define. It's what a reasonable and customary person would normally think of, and I think we can all agree that in a vast majority of circumstances, most people are going to agree on what's reasonable and what's not reasonable. Stuff that's just out of the ordinary, holes in walls. Somebody takes a knife and cuts the carpeting as compared to the carpeting fraying over a period of time. I think in most instances, you can kind of tell what's reasonable and what's unreasonable.
I think I want to jump ahead. This seems like there are a lot of questions about holes in walls because of paintings and hanging things on the wall. Is that
Yeah.
considered reasonable or unreasonable, or I think damage that you get just because of you living in the apartment?
I think if it's, again, it's a reasonableness test. The judge would ultimately say if people are hanging a couple of pictures up and things, I don't think that's unusual. I don't think a landlord can expect to have bare walls and it's what reasonably. But if they're putting 65 nail holes in wall to put up 65 different things, and it causes a mess to the wall in that respect, I think then you're getting on the less reasonable side, I should say. Ultimately, it would be the judge's decision as to what actually is. You can't sit here and say, okay, 10 holes are okay, but 11 holes aren't. It's the whole scheme.
All right, and I think this question came when you were talking about the complaint procedure and what happens. And I think the question is, the process that you described, is that only for complaints that come to a government agency and your office, or does that process happen if the complaint was made to the landlord only?
I think that's in reference to what's retaliation or not retaliation. Complaints to the landlord can also be considered to be retaliation if it deals with the comfort and safety of the home. So if you're calling because your furnace went, you just don't happen to call government, you call the landlord, and you call the landlord every day because the furnace isn't fixed, and the landlord says, this person's a pain in the neck, I'm going to get them out. Making a legitimate complaint for something like that, which was the landlord's obligation, could, by not agreeing to renew to them, could constitute retaliation.
Okay. All right. Next question is, does the current eviction moratorium have anything to do with ending lease terms during the time period?
And I think we addressed that issue with holdovers. The actual execution of an eviction, well, until Monday, courts haven't been taking cases for this type of thing. So starting Monday, holdover tenant applications could be made to the court. I don't know if they'll be accepting them or not. I'm telling you, courts are going to be flooded. There have not been cases filed since middle of March, so we're talking almost 2 months, and there's a huge backlog, and the floodgates are going to open up. So courts are going to be really backlogged to get these things going. But that said, theoretically, a case could be started on Monday, and if the court's taking them and open, and there's a time available to hear the case and stuff, the case theoretically could still be done, but the execution of the warrant, where you go to the sheriff, that can't take place until June 20th. After June 20th, the execution can take place for a holdover tenant, but cannot take place for a non-payment tenant if the non-payment is due to a COVID-related financial hardship. And that's until August 20th can it be executed.
All right. And the next question, I think you mentioned this. It says, under pandemic exemptions, as recently enacted by the governor, must landlords allow tenants to use security deposit as rent, even if tenant is otherwise able to pay rent?
If the tenant asks for that to happen, that they need to have that take place because of the COVID-related issue, then says the landlord must accept.
Okay. Next question, does the pandemic cause any change in law regarding the possibility of an early cancellation of the leasing agreement by the tenant?
No. We're getting that situation. Ithaca would be a prime venue for that. Students are hearing that I don't know that it's been decided yet at Cornell and Ithaca, But at other institutions, there's talk of just having remote learning for the fall semester, maybe longer, I don't know. So what we're getting complaints from people who have been notified that their schools may not have on-campus presence. And they say, well, I signed a lease for the whole year. And if I'm going to be remote, I can be remote back at home and not pay the rent. And I want to be able to get out of my lease. There's no provision in the law for that.
All right. Next thing we have is under EO 202.28. If the tenant uses their security deposit to pay rent and the tenant fails to make a 1/12 payment for a single month, is this cause for an eviction?
Well, first of all, it wouldn't go into effect until for 90 days anyway. And there's no designation in the the governor's interpretation would have to go here. But my position is my thought process is that you could make an argument that they're paying the rent. What they're not paying is 1/12 of a security deposit. The security deposit is not quote unquote rent. It's a security deposit. So if I pay the base rent, but I don't pay the other amount, then that's not a failure to pay rent. But I can see how the argument is on the other side too, but that would have to be decided by somebody interpreting what the executive order says.
All right. This next question is around, let's say the landlord wants to sell the house and wants to have people come by to tour the house. During COVID-19, do tenants have rights to tell landlords not to let people come into the house?
No.
Okay.
But there has to be reasonable accommodations made. I've had some experience. That what we've had circumstances where some family members own a house and they're trying to sell it, and it wasn't that somebody wanted to come and look at the place. What it was that they had a buyer, but the buyer's appraiser had to come and appraise the house, and arrangements were made by family members to have the tenants do a virtual walkthrough, video the whole thing to be able to show it.
All right. Next question. I think you might have touched on this, but I think people might want to hear it again. Is there any obligations for a tenant who wants to break the lease to find a sublet or an alternate tenant?
No, there's no obligation at all. The problem is that the tenant is on the hook until a new tenant comes in. So there's some incentive on the tenant's part to try and find a subtenant. If the tenant does find a subtenant, what the rule is that unless the subtenant is unreasonable, like you bring somebody in who's has a good credit background, is willing to pay the rent, same rent as the prior tenant was, and the landlord refuses that person, that absolves the main tenant of having to fulfill any obligations under the lease, because the landlord was being unreasonable in not accepting a tenant, but a subtenant. But the tenant is not obligated to do it, but it really would behoove the tenant to do that so that they could get out of their obligation under the lease.
Okay. Next question is, what is in place for landlords who to collect money from tenants who they feel have the ability to pay the rent?
Ask them for it.
All right. And can you speak to the landlord's obligations to accept Section 8 funding under the HSBTA.
Correct. What happened, I'm glad that was brought up. That was a good question. Landlords it's a source of funds. Landlord cannot discriminate on the source of funds. Child support payments, Section 8 payments, they can't say, I don't accept Section 8 payments. You cannot discriminate on someone based on their mode of payment of rent.
Okay. And another question, can you, to return the deposit, is that 14 business days or calendar days?
It says 14 days.
14 days, all right.
It doesn't say 14 business days.
All right. What happens to security deposit provisions when tenant has vandalized apartment?
The tenant's responsible for all damage, regardless of how much was paid in the security deposit. Let's face it, the security deposit is an arbitrary amount. It just happens to be statutory now. It can only be 1 month worth. But that's just a number. The tenant is responsible for any damage the tenant causes. So if the security deposit's $1,000 and the tenant causes $1,500 worth of damage, they still owe for the extra $500. It's just the way it is.
All right. Another question. My roommate moved out this month. I used to pay half of the rent, but will I now be responsible to pay for the entirety of the rent?
Yeah. The when co-tenants come in, when a bunch of people, let's take, it's even college kids, 5 go and rent on an apartment, they're responsible for the total rent. And normally what the agreement is, unless otherwise provided, is that it's called joint and several liability, which means you're individually responsible and you're jointly responsible. So everybody, all 5 are responsible for the total amount. Now I know they've divided it up into fifths, but when one person leaves, the other 4 still have to make up for it. Now it could be that those 4 can then sue the 5th person to get his or her share of the rent that was due. But as far as the relationship between the landlord and the tenants are responsible for that lump sum to come over to the landlord.
All right. Next question is, assuming multiple people wish to rent a unit, the landlord makes a decision about whom to rent to. How is the landlord determined to have discriminated against someone who was evicted in the past or has negative landlord references, since that landlord will be making a decision regarding whom to rent to?
It just comes down to proof. It's how can you prove the basis of why you chose one tenant over another tenant? It's a proof problem more than anything else.
All right. Do you ever, or does your office ever enforce broker, property manager corruption or fiduciary duty?
It depends on what the facts and circumstances. That's not, we have an investor protection bureau. We also are given jurisdiction for prosecuting repeated and persistent illegality, meaning violations of law, violations of a statute. So if it rises to that particular level, our office would have jurisdiction to do something like that. And then we choose, our office has to choose what cases we feel that we can prove and bring.
All right. Next question is, if no rent has been paid since March, can the landlord issue the 14-day pay rent or quit at the time? Or would that count as starting eviction proceedings?
Yeah, that's one of those gray areas. I've had people say both things. Had some that have said that you can't do that, but others say, well, that's really not the start of the proceeding, and we just have to get the thing started. and nobody's decided yet. I will tell you though that our office has taken the position, and it's going to change now that courts are finally opening up, but our office took a position that if a landlord, let's say last week, gave a 14-day notice, pay or you're going to be evicted, they would have had to disclose in that notice that an eviction proceeding would be brought, but not until the courts open up, because it could be deceptive if a tenant's given that and they didn't know that evictions were on hold because the courts were closed, that they would have, it would have been deceptive to say, hey, if I don't get out of here in 14 days, I'm really in a lot of trouble, when that wasn't the fact. But now that it's changing and the courts are opening up, especially if courts are opening up to both non-payment and holdovers in particular, you can start the 14-day notice then.
All right. Next question is, are there standard or form letters to use in the various steps of eviction?
You'd have to check and see. I think there's a common form that's used on the first 14-day notice. I've seen those. Our office doesn't have any. We don't get involved in that part of it, but I've actually seen the 14-day demand or pay or get out notice, and there's a legal form for that.
All right. Next question is, transferring leases when property is sold. Do you need a new lease, or does the old lease hold, and can you charge legal fees for eviction from the security deposit?
Good question. The person who purchases the landlord's property and becomes the new landlord takes the property subject to outstanding leases. So you don't have to have a new lease. You're still governed by what the lease was. In fact, you're bound by what the lease was. If you want the person still has 6 months more to go on your lease, on their lease, but they want the new landlord wants them out so that she can move in. You can't do it. You got to let the lease run until the end of time. What was the other part of that?
Can you charge for, I think it was
attorney's fees.
Yes, for the eviction.
Attorney's fees, if the parties agree, if there's an agreement in there for the payment of attorney's fees when having to do an eviction, yes, you can charge the attorney's fees, but it's not, attorney's fees are not considered to be part of the rent. So if the landlord or if the tenant came, you can only get a judgment in the eviction proceeding for just the base rent, and you have to sue separately to get the attorney's fees. But you could charge them, and you could charge it against the security deposit.
Okay. Next question is, can you evict someone due to continued reported domestic violence in an apartment?
If that amounts to an objectionable tenant causing injuries and assaults and things like that, you could do that. But there's probably an easier way, and that way is that if it's a domestic situation, that the one who's being injured, the victim, could get an order of protection through the criminal courts or through family court to have the abuser ordered out.
Thank you. And you mentioned that landlords could show the apartments during the pandemic. Are there any requirements or best practices on how they should do it?
I suggest talking to the health department or something about best practices, but it would have to be on reasonable notice under reasonable circumstances. So it's hard at this time to determine what's reasonable given the unreasonable situation that we're in. But I think appropriate notice, an opportunity to have the current occupants out for a short period of time. I don't know if an agreement can be made regarding cleaning the place up, or that there be no touching of anything as they walk through and just looked around. You just have to we all have to be reasonable people in unusual times.
All right. This is another interesting situation. 14 tenants. 14 tenants signed a lease back in October 2019 for an entire house, which has several apartments within it. The lease was beginning on June 1st, 2020. The first 2 floors included in the lease were under construction and due to be completed by June 1st for the move-in. We were notified 2 days ago because of the COVID shutdown orders, the landlord will not be finishing the construction until June of 2021. While she did offer 5 of the tenants an alternate apartment, this is not what we signed up for and would like to know our options. I think our main question is, are we legally allowed to break the lease and get our deposits back?
My suggestion is to talk to your attorney. If it's a material breach of the lease, it would be able to be breached in its entirety. I mean, vacated in its entirety. So consult your attorney about what that process is.
All right. Next question. If an apartment is not approved for Section 8, how can this tenant be accepted to rent the apartment?
I assume if the tenant's willing to pay all the rent. I don't know. We've got to kind of separate what I refer to as the golden rule, which is whoever has the gold makes the rules. Whatever Section 8 requirements are, because they would pay that share, they would have to make that determination. I don't know how, if the landlord lets somebody in, all the landlord's really concerned about is getting the rent and having the property kept up. And that's the way the law is designed, because you can't discriminate against somebody on Section 8. So if for some reason the tenant can come up with the money for the rent, then tenant stays. Here goes in.
All right. And I think this is our penultimate question, unless we have a couple more coming in. Can a landlord refuse to rent based on negative references from previous landlords?
I guess it depends on what the negative recommendations are. If they were, they caused they got a report they caused damage to the property or something like that, then that could be a factor in the determination. Not the fact that they were evicted. Just
okay. And the last, this is just some information. Section 8 is doing virtual inspection.
Okay, good.
Yeah. And last question is, oh no, we're getting more questions. Can landlords legally restrict number of occupants because of infrastructure concerns such as water supply?
Yes.
Okay.
But understand now, I'm glad you brought that up, because there's kind of something that landlords don't understand. And this is pretty important. I would think it would be important if I was a landlord. And that is, landlords cannot tell tenants, other than safety, habitability reasons, you can't have 15 people in a 1-bedroom kind of thing. But if the landlord says, I'm renting this to Joan Smith, and Joan Smith only, no others may habitate in there, that provision is void. The real property law allows the tenant to bring in their immediate family, so it could be kids, spouse, kids, and one unrelated person in their immediate family. And even if there's a provision in the lease that says you can't bring in anybody to live with you, that's void. So landlords, you need to take that into account, that someone that you're renting to, if you think you're only renting to one person, there could be 2 people that end up there and you can't do anything about it.
And the next question is, can summary proceedings that were already on the court's docket but adjourned to dates after the courts closed be continued once courts open? And similarly, what about the 14-day notices that were served before the original executive order?
We talked about that one, I think, before. But yes, the proceedings could continue, except executions can't be entered. Execution for holdover tenants can't be until June 20th. And non-payment due to COVID-related financial situation can't be executed until, well, those cases for COVID financial-related reasons, as I mentioned, the executive order runs from June 20th. You can't even start a case between June 20th and August 20th. Conceivably, you could do that now up to June 20th, although I think that's probably going to be changed because it doesn't make sense. It's an inconsistency. Those can't even be started, and the executions can't be entered until August 20th.
All right. Hold up. We still have a couple of questions coming in. Do you still have some time, Mike?
They're firing in, yes.
All right.
Let's go.
Okay, we're going to keep going. Does the number of people rule go for housing authorities? I know that they limit tenants and will evict if someone moves in.
You broke up. I didn't get that whole thing.
It asked, do the same occupancy limits exist for people in public housing?
I think public housing has their own rules. It's whatever the public housing rules are.
All right. And in regards to having an additional person in your space and not getting penalized for that, as you've just mentioned, any idea how long that will last?
It's been in existence for a long, long time.
So if I'm correct, this is not a new provision.
It's not a pandemic thing. That's always the case.
All right. And so somebody wants to follow up on the number of tenants. It seems to be saying that you cannot restrict number for any reason, assuming they are immediate family or immediate family and one unrelated person.
Well, if you have a 1-bedroom and 15 kids, then maybe there can be some type of a issue, but the statute says your immediate family. So I guess if you have 15 kids, can't do anything about it.
Reasonable probably comes into play.
Yeah. I mean, then the government housing authorities may have an issue with occupancy.
If a septic system will accommodate only 8 people, can a landlord?
That could be a factor. That could be the safety thing. Yes.
If utilities are included in the rent, can additional people be a reason to add to the utility costs in the rent?
Nope.
No.
That's why I say landlords, you got to take it into account when you originally set the rent at the beginning.
All right. Somebody says, it is my understanding you can write in the number of people per the building department's rule.
Yeah, I mean, we're getting back to the safety thing. If the housing, the code office would only allow 4 people or whatever, that's okay. If it's for safety reasons, it's just that the landlord can't limit it and charge more for every person that comes in.
All right. And another question, if the apartment to be resided in July 2020 is still under construction due to COVID delay, can a tenant not pay rent or live there until it's completed? Or do you suggest they get out of the lease?
I can't make a recommendation one way or the other, but the landlord should not be able to collect rent if it's not habitable at the time that the lease is supposed to start.
All right. Thank you very much, Mike. Are there any other questions? We've got a couple of couple of minutes here still.
Fire any questions? Now's your chance. Who knows? We may never be in remote locations again.
Well,
Maybe
honestly,
they'll have to come down and visit us. That's what I want to say to people is join us, come down. This has been a great exchange. I love the questions. We'd love to have you at a social distance at Cornell Cooperative Extension on Willow Avenue whenever it opens up on the second Thursday of the month at 11 a.m. I see another few more that came in.
One thing is about resources and numbers to provide people with future questions or follow-up.
Look us up, the New York State Attorney General's office. We're in Binghamton, the Binghamton office. You can call us. Anybody in the Ithaca area, we have our phone system is set up so that our 800 number rings at the nearest office to where you're calling from. And it's generally based by area code. So 607 calls come into Binghamton, 315s go to Syracuse, and all the other ones. So if you call our number, which is 1-800-771-7755, 1-800-771-7755. And you call that number in Ithaca, it should ring in our office in Binghamton. There's also complaint forms available online at the Attorney General's website. If you have a consumer complaint about anything related to a business, could be landlord tenant, could be you bought a widget at a store and it doesn't live up to what it was advertised to be, file a complaint with our office. We can't represent you, we can't sue on your behalf, but we can attempt to mediate your complaint with the business. So feel free. We have a consumer representative on staff who takes these complaints and sends them out. And we hopefully will be able to get the thing resolved with as little hassle to everybody as possible.
Well, on behalf of Cornell Cooperative Extension, I would like to thank everybody for participating. And as Mike said, we do this the second Thursday of every month. He'll talk about a different topic. We love to have you folks come down and join us at CCE if possible, but we'll also maybe try to do a little bit more things to make it available to people virtually as well. We're going to record this and post it on our website. And again, if you have more questions, you can email Mike directly, or you can contact us at CCE Tompkins, the Consumer Issues and Money. I'm Kenneth McLaurin, and we'll do our best to try to connect you with resources to help you. Thank you all, and have a great evening.
Thank you.